Okay, everyone, for those of you who haven't met, my name is Dave Sabina. I'm a SR&ED and tax practitioner from the Burlington area. I guess I've been involved in the claim process since around 1993. I'm a chartered accountant by training, but a lot of the work that I do will be on the technology side as well with engineering teams that I work with. Today what we've done for the tail end is we've taken a lot of the information that you've talked about the last couple of days, how to decide what an eligible project is, how to document it, and then applied those principles to income tax court legislation and precedents. So what we're going to do is we're going to go through issues on the technology side, whether companies qualified and why or why not, and look at what the court said, both where the taxpayer won and where the taxpayer lost, and what we can learn from that and how we can apply that to our situations. And then we're going to do the exact same thing for financial issues. We're going to go through all the areas of cost: wages, materials, subcontractors, overhead, other issues that affect credits, such as CCPC status. And we'll talk about what we call the black and white, and then the gray areas. So a lot of times things are black and white. You go to court and the judges, hey, this is clear, nice clear judgment. But very, very often they say, well, this isn't so clear. This is an issue that's ambiguous or requires application of judgment. And that's really where all the opportunities start to pop out, and where, if you understand the principles, you can maximize. It's the case of Northwest Hydraulic Consultants. It's probably one of the landmark cases on technological eligibility. And what happened here is we had two university professors that were engineers and PhDs and arguably world leaders at what they did. And basically the argument that the CRA made is, you guys are so smart that nothing could ever create a problem for you. You know everything there possibly is to know about engineering of aquatic devices. And they go on to say that, you know, we have a river implementation scheme, but all work described in the project refers to standard devices and processes, which are routinely used in similar design situations around the world. Okay? So they're going back to the technological uncertainty part and saying that combining standard technologies and devices is eligible if non-trivial combinations of these devices carry uncertainty. So they're admitting, yeah, there's no new device here. We're using radial walls and sluices and dams and rubber dams and all kinds of different devices, but they're saying it's the combination of those, much like a chess game. Sure, we know all the pieces move, but it's the particular combination of those pieces in what order that can make the difference between winning and losing the match here. Okay, so the courts come in the analysis, and the judge says the respondent's position, that's being the CRA, is ably articulated by Mr. Yaskowicz, the CRA reviewer, was essentially the appellant admitted a world leader in the field of hydraulic model testing by its own excellence sets a standard for what represents routine engineering or standard practice. In other words, they know everything that there is to know. Nothing that they do could involve any uncertainty because they're just so clever. He goes on to say, with respect to this, I think this is an unrealistically high standard, indeed a standard of perfection that would encourage SR&ED in Canada. Okay. So then he goes on to look at 5 out of the 17 projects in question and rules that the 4 largest are in, and more in particular, that the largest of those was exemplary of an SR&ED project. So exemplary, he could not understand how the CRA could ever have questioned it in the first place. And actually make some comments that they should reevaluate their circulars and relook at how they're doing stuff. So one is a river diversion dam. And what the client says is that the uncertainty and related investigation looked at the optimal combination of weirs, radial gates, and wells of varying different types, sizes, materials, whatnot. Right? So each of those would be a variable. And as we said, every time we add a new variable, the project grows geometrically stronger. The judge looked at this and admitted that these guys are world leaders at what they did, and yet they didn't get it on the first try. As the CRA was saying, that was routine. They actually experimented. They looked at 5 different options and then physically prototyped 3 of those to compare them. The judge is saying, like, if you knew what the right answer was, why would you look at 5 alternatives and prototype 3 of them? You would just install the right answer and collect the money from the client and go make more money. You wouldn't do all kinds of experimentation and waste your client's money. So again, and I said that he looked at really different principles that, yes, would apply in a different scenario. So they talked about the riverbed here, how it was different, how it wasn't easily modeled, how it had different vagaries in it, how it had different flow rates, okay? How there really was no existing model anywhere in the world that would allow them to do this without this experimentation. And the judge agreed. So they identified the variables, and they showed work directly related to evaluating those variables and making a conclusion why, in this particular situation, one was better than the other. And the CRA was unable to show that there was any definitive answer on how to do this ahead of time, which of course there wasn't. Okay? So the client won, and the judge commented, again, that they shouldn't have even really been in court on that. Even the very small one, and I don't even know why the judge kicked this one out. I thought all 5 projects were actually fairly strong, but he let them kick out the smallest one, I think more just to give the CRA something to chew on, right? So they talked about a sediment study to devise a solution to decrease sediment deposits for a particular area, and they analyzed 3 alternatives here: Flushing, Dead Pond, and Extended Peninsula. Nothing innovative in the final answer that would be apparent as using standard techniques. Now, this is one of the ones where I can kind of see where the judge is coming from, and the principles apply a lot in current judgments, which is, and this is the argument the CRA is going to successfully make, that you didn't try to combine different methods, or look at different methods and realize limitations of any one of them, and then maybe use ideas from another method to improve that. You looked at 3 or 4 different methods, picked method 2 and used it, and it worked. Okay? Now that's a very dangerous position. If it looks like that's what's happening in your project, CRA and the courts are likely to say that's just market research. That's finding the square, what existing standard practice was at the start, and using that method. Okay? So it's more often when you're saying, none of those methods actually works perfectly here. There's shortcomings, but we have ideas on how to make that method better, that you would have an eligible project. All right? So again, Northwest Hydraulics, all of these cases you can download from Tax Court of Canada website. They're all free. They're public information. So what I tend to do is pick cases that correspond to my clients' industry, situations, facts, whatever, show them exactly what the court said, why, and allow them to map that to their fact situation. So if we have a similar fact situation, we can argue we should have a similar treatment. Okay. So as I said, Northwest Hydraulics, probably the landmark case on technological eligibility, and since it came out, maybe about 10 years ago, it's been cited in pretty much every other case on technological eligibility. They're always going to keep referring back to that case. So just before we go on to Rainbow Pipeline, the closing remarks I like on Northwest Hydraulics, just because it's such an important case. The judge recognized and commented on the legal implications of the income tax definition of experimental development. He also referred to the French wording of the legislation to clarify any ambiguity which he found might be found in the words including incremental improvements thereto. Okay? So the courts take this including incremental improvements thereto very seriously. He says, the addition of these words in 1995 appears to have been in response to the concern that achievement or attempted achievement of slight improvements was not covered. Okay? He goes on to say, I should not have thought it was necessary to say so. Most scientific research involves gradual, indeed infinitesimally small progress. Spectacular breakthroughs are rare and make a very small part of the results of SR&ED in Canada. So again, you don't have to be 10% better than you were before. You could be a tenth of 1% better as your objective, as long as it involves technological uncertainty. Okay, Rainbow Pipeline. Rainbow Pipeline's an interesting one where the client identifies about 140 different areas where they're looking at a pipeline, and they have a contract to maintain this pipeline, a big pipeline in Alberta, and they spend about $4 million, let's say, on it, $2 million of which they claim as SR&ED expenses. And the CRA comes back and says, well, you're just trying to find out the problems as part of your routine engineering or routine maintenance contract. Since you're getting paid for this, there appears to be no technological advancement. And again, that seems to be a bit of a mindset that if you're doing it for free, it's good, but if someone's paying you to do it, there can't be any technological advancement in there. It must be commercial. I always laugh at that. And I say, well, shouldn't the science drive the claim, not whether someone's paying me? They say, what do you mean by that? And I said, well, if you offered me $1 billion to build you a time machine, are you saying because I'm getting the $1 billion, there's no uncertainty anymore, that building a time machine is very simple now? Well, of course not, but that's the whole point, that getting paid for something, the fact that you're paying me for something indicates there probably is a problem, especially the more you're paying me, must be a big problem or you wouldn't pay me so much to do it. Okay? So the sale of experimental production, we'll talk about that, is completely irrelevant as being paid under it. So what happens here is they're saying, well, all of this work that you're doing is within standard practice for your industry. And they go on to say, well, not really, that they have third-party evidence by the National Energy Board. Okay? And around the time that they're doing it, that they say National Energy Board held an inquiry into stress crack corrosion on Canadian oil and gas pipelines. The company was invited to participate. They went in the study and concluded that they didn't know the cause of the pipeline ruptures. Okay? They then go on to talk about a company called an agency called CEPA, Canadian Energy Pipeline Association, whose members agreed that they identified these problems. So the client came into court and had very convincing evidence of experts that these were industry problems that everyone agreed had no routine solution and need to be investigated. The judge put a lot of emphasis on that. Okay? So basically, what happened is the client came up with a whole bunch of issues that the judge thought was very strong evidence of SR&ED work. So the areas of uncertainty or departures from standard practice, uncertainty is caused by departures from standard practices, what caused the stress corrosion cracking? What caused it to form? What caused it to grow? What were the factors or variables? They said, we know some of them, but we don't know all of them. And the industries that we're dealing with and are members of agreed that we don't know all of them. I've written papers on what we know and don't know. So there's a lot of credible evidence of what the standard practice or nature of the science was. They talked about what parameters caused the formation, the initiation, and the growth. And were they different? Were they linear? Were they nonlinear? How would they work? How to control the growth rates? How to predict it? So all of those things, the judge said, those are the evidence that the client provided of other industry associations who looked at similar studies and concluded that they didn't have the answer was strong evidence that the client took reasonable steps to do this. And ultimately, the client was unsuccessful. They were unable to determine a lot of the causes. So the judge says the rejection after testing our hypothesis is nonetheless an advance. Okay? Often it's the activities that fail commercially that are stronger evidence of technological uncertainty. You're not going to go waste $100 of your company's money to do something that didn't work unless A, you either thought it would work, or maybe you thought it might not work, but you still wanted to understand why. Either way, the failures are very strong indicators of SR&ED. They're not proof, but again, the courts are going to smile on those to say if you're analyzing alternatives, instead of going right to the final answer, it's probably because you wanted to understand why something was happening. Okay, so another great case where the taxpayer won. CW agencies. Here's one where the taxpayer loses. So in this case, it's kind of an older case on software, going back to 1998. And really what we talk about